Does the Free Exercise Clause of the First Amendment excuse criminal conduct? What if a person's religion allows or even requires certain actions that are illegal? In 1878, the Supreme Court heard a case that would shape the interpretation of religious freedom for generations to come: Reynolds versus United States. George Reynolds, a devout Mormon living in what was then the Utah Territory, was convicted of the crime of bigamy in federal court. At the time, the Mormon Church required adult males to practice polygamy where circumstances allowed, on pain of eternal punishment. Reynolds had received permission from church authorities for his second marriage. Both he and church authorities cooperated with the prosecution, even providing the government with a list of witnesses to test the constitutionality of the anti-bigamy statute. Reynolds argued that he should be acquitted because his religion required him to enter a second marriage. Specifically, he argued that his conviction was unconstitutional under the Free Exercise Clause of the First Amendment. In his first decision on the meaning of the clause, the court unanimously ruled against Reynolds. Chief Justice Waite reasoned that the Free Exercise Clause protects belief, not conduct. Citizens have freedom to believe what they want, but not necessarily to do what they want. As evidence, he quoted a previously obscure letter from President Thomas Jefferson to a Baptist congregation in Connecticut. In that letter, Jefferson wrote that the Free Exercise Clause allowed the state to regulate citizens' social duties, and that it built, quote, a wall of separation between church and state. Although the government has no power over mere opinion, Waite wrote, the Free Exercise Clause allows the government to punish actions that are subversive of good order. Polygamy had always been illegal in the United States and was a, quote, odious practice that greatly endangered society, he wrote. More generally, the court rejected the idea that a defendant could escape the requirements of the criminal law because of his religious convictions. If that were the case, Waite wrote, quote, every citizen would become a law unto himself, and government would exist only in name. The Reynolds case is a landmark for two reasons. First, the case's distinction between belief and conduct would reappear in subsequent court decisions on religious freedom, although the application has not always been consistent. On some occasions, the court has suggested that the state's ability to regulate conduct is quite broad, that the state needs only some rational basis to do so. On other occasions, the court has indicated that the state must show that it has an important interest that justifies the regulation, as in Reynolds itself. Second, Reynolds is famous as the first time the court used the metaphor of the wall of separation between church and state. That language from Jefferson became an important and controversial part of the court's subsequent religious freedom jurisprudence. Although the Free Exercise Clause guarantees citizens complete freedom with respect to their religious beliefs, it gives less protection to citizens' conduct. If the state has important reasons for prohibiting behavior, religious requirements to violate the law will probably not be a valid excuse. As the court said in Reynolds, the Constitution does not allow each citizen to be a law unto himself.